I'm sorry, but let me just see.
No, it's there. Fine.
I'm extremely sorry.
No, it's there.
My lapse, I should have carried extra copies.
No need.
I'm not if your lordship sees that one page note, part 1. So C, D, and E is what is to be touched. Question 4.5 is to be dealt with. On part 3, I will make it very short. Part 3 of my notes, I'll make it a short argument, write the one decision and let it fly. If your lordship don't have copies, I do have copies of it.
So not that. So it may take a little longer than the 40, than the 35 minutes your lordship has indicated. And I can assure your lordship, I will one copy. One copy.
Brother, would like you to tell us is what are the cases, how many cases are there?
What are the points involved so that if there are overlapping points, one argument can.
Yes, sir. Not wherever there is an overlapping point.
No, we are asking a bit of housekeeping about
Housekeeping.
how many petitions.
How many petitions, Lord? I'll give you your lordship. 17 or 18 months.
17, 18. Now, what does each individual petition relate to?
So, Lord, I'll tell your lordship, there are, I'll make it very clear, Lord. There will be some petitions.
During lunch hour, if a sheet can
We'll
be.
give you a sheet. Lord, we'll give you a sheet of the petitions and what they relate to. There's a whole chart made. Mr. Giri had it.
Amendment acts of 3 states.
Yes, Lord. So, I'll tell your lordship, Lord.
Yes.
Lord, 3 states amendments are there. Some petitions will challenge one or the other amendment. In writ petitions, Civil 24 of 2016, all of them are challenged. All the 3 legislations.
23.
24 of 2016 challenges all 3.
We have the file of 23 with us.
Lord, 23, I'll tell your lordship.
Are you arguing 24?
23, yes, Lord. No, I'm arguing writ petition 24. Writ petition 23 is the petition filed by the Animal Welfare Board of India, where my learned and 2 individuals, Anjali Sharma and Mr. Jaisam, my learned colleague, Ms. Karia, had appeared on the last occasion to point out that there is presidential assent and she wanted the others to start because her view may be somewhat tempered because and as she indicated on the last occasion, she's given a written note which reflects the view that they've taken.
Argument to be mainly on interpretation of the entry.
Yes, interpretation of the entry, Lord, as also whether they are protected under Article 29, the effect of the presidential assent and challenge, if any challenge that is laid to it, that is, and whether the judgment is, whether the law is brought in to nullify Nagaraj. That's the 4 essential heads to be left. I'm not, if I may just point out, Mr. Giri will be appearing in writ petition 25, Mr. Grover in 3 matters, which is Jallicut 2, and he's dealing with the anatomy of a bull. And
That is writ petition number?
That's writ petition 27 of 2016 and 6 of 2018 and 10 of 2018. But may I do this? I will give your lordship a chart like this for your convenience. It's there. But we'll just make copies of it because that's the one I have. So, and then there are some, but we divided it council-wise who's appearing in.
No, that's what we.
We'll give it to your lordship, Lord, in 5 minutes. I'll just get copies made. There are another about 4 petitions which are separate, Lord, which are distinct where there may be other council who may want to supplement. But this is the broad structure of the matters. There are 15 matters.
Same thing.
I'll just get that photocopied if your lordship permits.
You were on the writ petition 24.
24 is not 24.
Which covers all the 3 amendments.
All 3, and I'm in writ petition civil 1059 of 2017.
Just 1 minute, writ petition.
1059 of 2017, which relates to Maharashtra.
No, but if 24 covers Maharashtra also,
Well, yes.
then
Yes.
what is the.
I'm just pointing out which are the matters I'm appearing. And 1152 of 2018, which relates to Karnataka. I will be treating them all together, not under one umbrella, because really there are, since the first matter covers all legislation, so I will treat them as one. And that's the reason, Lord, we will just do this. We'll go straight away to that. Lord, if I may,
What would be your main thrust? Whether Nagraj,
But yes, my main thrust, one of the main thrusts is going to be that Nagraj is sought to be overruled. Nagraj has, and the review, had determinations on fact. And those determination of fact have gone untrammeled, unchallenged, and they cannot be undone by this kind of legislative activity. Secondly, that the legislation as it stands,
as it is sought to be brought out, has excessive delegation. The reason is they brought in just the bare provisions and brought in everything within the rules. So the so-called exceptions that they create, or the protection protection that they create in terms of the activities to be carried out, whether Jallikattu or Kambala, it's not in the legislation. It comes out in the rules. Now, whether that can at all be done, that's the issue that is to be placed before your lordship. Third issue, and therefore,
But we always reminded that this is a repetition of Article 32.
I'm sorry, Lord?
This is a repetition, they're all petitions of Article 32.
Yes.
We are concerned with fundamental rights
Yes,
being enforced.
yes,
We are talking about challenging a law on the basis of delegated legislation being in excess. It's just telling you.
yes, of course, Lord. I must say this, we have taken a number of grounds in the petition, Lord, as to why these legislations have to fail. So there are alternate pleas which I will take, and I will just dwell on them
On the basis of fundamental rights being violated.
but yes, of course, fundamental rights, but the whole issue is fundamental rights, the primary issue is fundamental rights, and that's the Nagraj
The
principle.
whole question is whose fundamental rights?
Yes, but, and that's been settled in Nagraj. That's been settled. So Lord, then the issue will be the personhood of animals upheld in
Do
Nagraj.
not address that first
Yes, Lord, I'll address.
and convince the court that
Yes, Lord, my friend Mr. Diwan is saying if your lordship could perhaps switch on or increase the volume because can't hear.
not hearing.
Not hearing very. Yes, but now it's. Yes, but I'll come to personhood. Not on personhood, there are two things which I must point out. And if I will just come straight away to personhood, Lord, your lordship. Yes, there are two parts. Lord, one of course is the matter. One of course will be the Nagraj principle, and and those parts of Nagraj have not yet placed in that they are obviously asking.
Not a citizen.
Yes, yes, of course, Lord. No, I'm not on
There are
90.
certain rights available to
Yes, of course.
non-citizen, like Article 14 and
Yes, of
21.
course, Lord. Yes, Lord.
So 14 and 21 perhaps, doesn't speak about arbitrariness without being for the citizen.
that is our, that's the submission, Lord.
So it's 14 and 21 we take.
Yes, Lord, 14 and 21.
Okay.
And Lord, I'm going to now place two things before your lordship. Please consider two things, Lord. The first point that we seek to make is when the constitution on this, on juristic personhood, and I'll begin with that. When the constitution recognizes that cruelty to animals is to be an activity which ought not to be perpetrated, and that is the reason for entry 17 list 3, the constitution recognizes the rights of animals. We have rights of animals under 48, 48A, 51, there are duties. And today, I don't need to really trouble your lordships to say that all of these will have to be read with part 3. They can't be read dehorsed part 3. So,
When you talk about, the environment, it immediately sort of call your attention to, for example, a tree.
yes,
Now a tree, if you go to the extent of saying that no person shall be deprived of life and liberty, so the tree also will be a person. Because we are talking about animals,
Even plants have life, as your trees have life, as you know. In fact, there are studies which show that supposing an elephant is grazing and it starts feeding on a particular tree, message goes. There's a mechanism by which the message goes to trees which are
Yes, of
located
course.
far away. And they start emitting a sort of poison. The anticipatory wave kind of thing, they sort of immediately know they're on their way to, so they are protected.
Yes,
There are a lot of mechanisms involved in nature,
yes,
which if you limit it to animal today, just think of the prospect of the tree also being protected. fact, there is one judgment in the Uttarakhand High Court, entered by, I think, Justice Rajiv Sharma, where he spoke about that trees having.
Yes.
So, you have to be a little careful about where you go.
No, not definitely.
Because in that even grazing might be an offense against
But I
the plant.
completely understand the reason. I completely understand what your lordship is saying. But in fact, there are decisions of possibly of Justice Rajiv Sharma. The decision is that Mohammed Salim versus State of Uttarakhand,
Yeah.
which was in relation to, which is part of the compilation which we will.
That's right.
So look, there are views taken. Some of those are actually under consideration before coordinate benches of your lordship's court. So we are not dwelling in that realm right now for the purpose of today.
Secondary argument, brothers, secondary point or primary point. In such a complex interplay of rights, would it not be safer to leave it to the legislature than taking us on ourselves the duty to categorize these rights?
But in fact, the rights with respect stand categorized. The rights stand in explained in Nagaraj. Today, the question is going to arise, is this an attempt to overcome what your lordships have declared as the law? And is that permissible at all?
In cases that is permissible.
Not in, it is
What we
permissible if
declared
basis
in a
is the law.
judgment, there are many constitutional amendments which are to invalidate.
Indeed, my lord.
There are many legislative amendments to invalidate a court order.
Yes, but of course there are, but
So that is a permissible
true, my lord.
activity for the lawmaker in a constitutional form of government.
Yes, but the only
Just because there has been a declaration of law, say the US example of recent thing,
yes, of course.
something that happened 70 years back continued, but now the court felt that that is not right. So it doesn't become for all times to come. It's not a theory of gravity.
No, but the only distinction that I would draw is not that once there is a declaration, unless the basis of that decision is removed, in terms of the law that your lordships have settled Lord repeatedly on a number of occasions, the fact is under the basis of the decision is dealt with, or the concerns that your lordships hold are dealt with, the defects are cured, mere bringing in of a legislation will not suffice.
There are two kinds of concern.
Yes, of
We
course.
can express certain kind of concern as individuals and certain kind of concern as judges.
But I was on the concern as judges. And I would say, Lord, that concerns,
Because many things we may not like as individual, but while putting on the robe and sitting on this chair,
I'm not, I
we might
completely
have to
understand.
forfeit our own prejudice, biases, likes, dislikes, and take another course.
Definitely. I was talking about not the individual philosophy of a person, whichever chair he or she may adorn, but about the declaration of law, declaration of the interpretation of constitutional principles and the declaration of law. Once there is a declaration of law by your lordships, that cannot be.
One small intervention there.
Yes.
See, Nagaraja was dealing with a different statute.
Yes, of course.
It was an attempt by the state to
That-
legislate, state to legislate, which finally it was found it was unsuccessful because it is a case of repugnancy under Article 254, number 1.
Yes.
Now, regarding the repugnancy, you are right, they cannot be opened, therefore they have resorted to amending the Act itself. Now, therefore, 11, there is no violation of Section 11 as such, because nothing will subject to your challenge to 11 3F in the Tamil Nadu case. Supposing you succeed on any other ground, you are succeeding. Otherwise, it's part of the same statute today.
Not the.
Number one. Secondly, as far as the question relating to whether an animal is entitled to personhood under Article 21, that is not a matter which is not open to reconsideration by the larger bench.
Not at all, Lord.
That's what we want to be very clear. So it's not as if it is cast in stone that it cannot be heard that that is not correct. They are not bound by the two judges' bench.
I'm not, with respect, not there are.
They're just saying that, these are the two.
Not, I'm very candid, not, there is
You
no
can go on
issue.
now, otherwise.
There is no issue, not, if your lordship believes that it has to be looked at, we have to address that. I'm not saying.
You don't know, stick to what they are doing.
But they would not like it to be cast in stone. I hope your lordship will treat it as cast in stone, but their argument is that it's not cast in stone.
Exactly.
And that's a proposition not which one has to deal with. So I have to not therefore.
So you proceed in your own way. I mean, now we have got,
Yes.
we are already behind by about 10 minutes, 15 minutes.
No.
10 minutes, we are late. We'll certainly give you the time.
I'm grateful. I'm most grateful. Now, not just two things. I had placed before your lordship two things. The proposition was in terms of Article 48, 48A and 51A F and G. I'm not going to, yes. GNH, I'm sorry, GNH, not F. No, GNH is what they say, it should be F and G. It should be F and G. GNH, I stand correct for GNH. My mistake. Now, not the point that we will begin with is, and our submission is that the right under 14 and 21 has to be informed by 48, 48 capital A, 51A, G and H. In this context, when we look at section 3 of the Act, section Number in this context, if your lordship sees section 3 of the Act, and let's have a look at that. What does section 3 say? Section 3 says, it shall be the duty of every person having the care to take all possible measures to ensure that the well-being of such animal and the concept of 10-11. Different categories of what is cruelty, E to E, F, and M is very important. I read it on the last occasion, I'm going to reiterate that. Solely with the view to providing entertainment, confines, or in fact, it confines or causes to be confined any animal, including tying of an animal as a bait and a tiger or other species, so as to make it an object of prey, cites any animal to fight, bait, 11, M and N,
Yeah.
M, N, N, lot.
Right.
N is organizing, uses or keeps or acts in the management of any place for animal fighting, or baiting any animal, or permits or offers any place to be so used, or receives money for admission of any other person to be any place kept or used for any purpose, or promotes part in punishment. What is also important is, my lordship comes back to L. Mutilates any animals or kills any animal, including stray dogs, by using the method of strychnine injection in the heart or any other unnecessary cruel manner. So, while the legislation recognizes that there are going to be instances, as we have referred to on the previous occasion in chapter 4 on experimentation, food, the legislature says you will not act in terms of any cruelty, and the whole purpose of that is to ensure that the purpose of the legislative entry and the purpose of the Act is met. Now, when we look at these legislations, one of the things your lordship is going to look at is the legislation is to enhance or protect the interrelationship of men, animals, and nature. And that is what the purpose of this legislation, that is the purpose behind the constitutional provisions. In this context, as I said on the last occasion, we had the Wildlife Protection Act itself also, which came in. And the Wildlife Protection Act is another species of legislation. It is not that that legislation does not permit the culling of animals in certain circumstances. It does. For example, in the Wildlife Act, in the 5th schedule, what there is in the 6th schedule, there are rats and animals in the Wildlife Act. I'm not, if your lordship just sees for a moment, in the Wildlife Protection Act, there is the schedule. '62. Just have a look at section 62 for a moment. But 62, get declaration of certain wild animals to be vermin. The central government may by notification declare any wild animal other than those specified in Schedule 1 and Part 2 of Schedule 2 to be vermin for any area and for such period as may be specified therein, and for so long as such notification is in force, such wild animal shall be included in Schedule 5. Schedule 5, there is which talks about, and please note, Schedule 5 will possibly be a working fact. So, common clause, page 86.
Yeah.
Common crows, fruit bats, mice, and rats. These are permitted provided there is a declaration and it has to be area specific and place specific. In this case, in this context, there was an issue which came up regarding the trade in ivory before this honorable court, and the 3 judges bench in 2003, 7 SCC, page 589. I've given the list of books. Just please give the book first to me. 2003 7 is right. Yes.
This bad,
And the provision.
they will not be animals under the
Not they're animals.
protection and prevention authority and will
Not
not have rights under Article 21.
No, not they're animals. They're animals. May I just say this? They're animals. They have
The
rights.
Later Act, we are saying,
yes.
85 Act is a later act.
Yes.
So animal is not defined as excluding vermin.
No, Lord. Let me just clarify.
It will go.
No, Lord. I'll just come to that. So I'm sorry. The Prevention of Cruelty to Animals Act is the 1960 Act.
Oh, sorry.
1960 Act.
It's a subsequent act.
Lord, I'll just tell. The Wildlife Protection Act came in because earlier we used to have different legislations in different states. It was a state subject, then it came together. We had a comprehensive legislation. In that comprehensive legislation, we had a national legislation which has undergone number of changes. Initially, wildlife trade was regularized, controlled. thereafter there has been a prohibition. There's an 85 amendment, there's a 91 amendment, there's a 2002 amendment. Will not, I can, there are various amendments. The purpose is what? That even, because I'm going back to that wonderful example your lordship took of a mosquito, so to speak. So not the point is that there are instances where there is going to be what we may call not a man-animal conflict, to use the word which is used in the context of environment, but where there are rights. For example, not the dengue, the mosquito that spreads dengue, we use pesticides against it. If you were to take the example of not certain religious sects, they actually, when they move about, they cover their mouth so that no insect should go into their mouth also.
Absolutely.
Because there is a level of sensitivity to natural beings. But that is part of religion, that's part of a practice which is followed by certain community. Today, our concern is slightly different. Our concern is that how is it that we are to treat animals in its entirety, except for exceptions, as in, and that is the reason I said all legislations will have certain specified exceptions for a social or a public or a purpose related to the, the rights to, when we balance the rights of humans and certain animals, that balance is there. But the point today is when the legislation itself, contradicts the principle in the Constitution, both in Part 4 and therefore read with Part 3, as also with the fundamental duties. And this legislation acts contrary to the very purpose of the legislative entry and the purpose for which the original legislation was made out. How can we consider it to be a valid piece of legislation? And therefore, it is in that context that I'm saying, please consider what the basis of, and the basis entire of the Constitution and these legislations is compassion for animals, which is what is stated in the Constitution. And in this context, if I may just draw this court's attention to that 2003 judgment, para 51 for a moment.
One more small interjection.
Yes, of course, Lord.
Clearly, so that we have it in mind. The 1960 Act, as you said,
Yes,
gave rights to all animals under Section 11.
Yes.
You say that the animals had the right under Article 21.
I'm sorry, Lord?
Animals, as defined in the Act,
Yes.
have rights under Article 21.
Yes.
If that is so, the Section 62 of the later Act, 1972, permitting animals to be condemned as vermin, which including Mickey Mouse, the rats, and the mouse and whatever it
Wild crow
mice,
also.
the crow which is black in color. So partly the reason why we don't know why it is being discriminated against. Will it not be will not those laws be violative of Article 21?
But I'll tell your lordship straight away, Lord. Those laws, not the, as I said, not the exception is made for vermin. That does not change the rule that flows through the Wildlife Act. To put it in another example, my lord talked about not something which I have a little understanding of because I have lesser understanding of other laws. But my lord talked about anticipatory bail in 21. Now you take away somebody's life. You do it, though Article 21 says life is sacrosanct. We take away people's liberty.
That right has been maintained under 1960 Act, right of human being, for the
Yes.
purpose of religious or even for normal food habit. So that capital punishment for eating is permissible. If you treat them as a person.
Yes, please. Now, I understand, Lord, as I was saying, Lord, just to add, even under the Wildlife Act, Lord, and I must point out, it is not that hunting is prohibited in its entirety. Under Chapter 3, it is permitted in exceptional circumstances, and those are in a sense similar to the exemptions made under the Prevention of Cruelty to Animals Act.
Mr. Luthra, why we are bringing
Yes, of
these
course.
subjects up
Yes,
again
of
and
course.
again? See, this is not really a constitutionally protected domain. legislature has interplayed with what is permissible, what is not permissible all through. In fact, when constitution came, we don't think any of these animal protection law, except some in the maybe municipal laws, the scavenger
No,
birds,
no, Lord.
they were protected.
In fact, Lord, I must point out,
No, listen,
there was a legislation since it is
Maybe-
shortcomings, therefore your lordship.
maybe we are-
therefore the parliament.
we are not wrong, we haven't.
1890 Act.
Yes. So if the legislature has all along done this categorization about which animal should be totally free from cruelty, where partial cruelty can be there. Now, what is so special about the three legislations you are attacking,
Yes.
that they should be treated as if it is a constitution, right?
I completely understand. Lord, I tell your lordship, the distinction has been made. While the legislature,
We are also saying this because all these legislations also takes protection of prevention of exceptional use of force or pain.
yes,
Now, whether they are breached or not, that's another question. That's a law and order question.
no, that's an issue of implementation. We are
Yes.
not in the course of implementation. The issue perhaps not will have to be seen.
How will you determine the expression or rather this necessary pain? They used such an expression, necessary pain. Or unnecessary. Unnecessary.
Namrata, I must tell your lordship, Lord, may I then come back to Nagaraj for a moment, because Nagaraj deals with this issue, not on pain and
Unnecessary.
unnecessary. So let's have a look at that. Would your lordship just come to Nagaraj for a moment, Lord?
Plans as well.
Namrata, please come to,
Taking plans as well. Going by the restrictions.
please come to para 32, which is at page 580 of the report.
I need to say. We need to tune it a bit.
Before I come to 32, Lord, your lordship may recall, no, just
I say is
page 559, para 4. ABWI has taken the stand that by no stretch of imagination can it be gainsaid that Jallikattu, a bullock cart race conducted as such, has any historical, cultural or religious significance either in the state of Tamil Nadu or in the state of Maharashtra, and even assuming so, the welfare legislation like PCA Act would supersede the same in a parliamentary legislation. AWBI should be, has also taken up the specific stand that bulls involved in Jallikattu, bullock cart race, etc. are not performing animals within the meaning of 21 and 22 of the PC Act, and that the MOEF in any view was justified in issuing the notification dated 11 July 2011, banning the exhibition of bulls or training them as performing animals on accepting the stand taken before this court. Then what para 5 is repugnancy, and 6 is the arguments by the other side saying that there's custom and there's a policy behind it. Number para 15, I would like your lordship to see. organizers, bull tamers, bull racers, spectators, participants, or the respective states or the central government. Since we are dealing with a welfare legislation of a sentient being over which human beings have domination, and the standard we have to apply in deciding the issues on the hand is the species' best interest, subject to just exceptions out of human necessity. Para 16 to 18 is the behavioral aspect. I won't trouble your lordship with that. I don't want to get into the consequences of the law that's set out in detail in the judgment. Please come straight away to para number 30. 32. In fact, 31 first, what we'll place. 31 and then 30. We have to examine page 580 of the report. That was the examination. We have to examine in the light of the above facts whether the events that have been conducted in the states of Tamil Nadu and Maharashtra are in violation of 311(1)(a) and 21 and 22 of the PC Act, read with Articles 51(a) and G and H of the Constitution and the notification dated 11 July 2011. The PC Act was enacted even before the introduction of Part 4A dealing with fundamental duties by the Constitutional 47th Amendment Act 1956. Earlier, the then British in India enacted the Prevention of Cruelty to Animals Act 1890 for the human beings to reap maximum gains by exploiting them with coercive methods, with an idea that the very existence of the animals is for the benefit of the human beings. During the course of administering the above mentioned act, many deficiencies were noticed by the Government of India, and a committee was constituted to investigate and suggest measures for prevention of cruelty to animals. Following that, a bill was introduced in Parliament, and ultimately PC Act 1960 was enacted so as to prevent the infliction of unnecessary pain or suffering on animals and to amend the law relating to prevention of cruelty to animals. So, Lord, I'm going to pause here and say your lordships are testing whether the pain that is to be caused is necessary or not, because the state says it's necessary and they will have to justify by what means of justification can they say that this is necessary. Is it not a case of trivializing and acting contrary to what the original legislation did? Now, let's read a little further. The PCA Act is a welfare legislation which has to be construed, keep bearing in mind the purpose and object of the Act and the directive principles of state policy. It is strike law that in the matters of welfare legislation, the provisions of law should be liberally construed in favor of the weak and infirm. The court also should be vigilant to see that benefits conferred by such remedial and welfare legislation are not defeated by subtle devices. The court has got the duty that in every case where ingenuity is expanded to avoid welfare legislations, to get behind the smokescreen and discover the true state of affairs, the court can go behind the form and see the substance of the device for which it has to pierce the veil and examine whether the guidelines or the regulations are framed so as to achieve some other purpose than the welfare of animals. Regulations or guidelines, whether statutory or otherwise, if they purport to dilute or defeat the welfare legislation and the constitutional principles, the court should not hesitate to strike them down so as to achieve the ultimate object and purpose of the welfare legislation. The court also has a duty under the doctrine of parens patriae to take care of the rights of animals, since they are unable to take care of themselves as against human beings. The PC Act, as already indicated, was enacted to prevent the infliction of unnecessary pain, suffering, or cruelty on animals. 3 of the Act deals with duties of person having charge of animals, which is mandatory in nature and hence corresponding rights on animals. Rights so conferred on animals are thus the antithesis of a duty, and if those rights are violated, law will enforce those rights with legal sanction. Then section 3 is extracted. Now, please turn overleaf. Both the above limbs have to be cumulatively satisfied. Primary duty of the person in charge or care of the animal is to ensure the well-being of the animal. Well-being means state of being comfortable, healthy or happy, forcing the bull, keeping the same in the waiting area for a number of hours, subjecting it to scorching sun is not for the well-being. Forcing and pulling bull by nose ropes into the narrow closed enclosure of Wadi Basal, subjecting it to all forms of torture, fear, pain and suffering by forcing it to go to the arena and also overpowering it at the arena by the bull tamers are not for the well-being of the animal. The manner in which the bull tamers are treating the bulls in the arena is evident from the reports filed by the AWBI. Forcing the bull into the Wadi Wasal and then into the arena by no stretch of imagination can be said to be for the well-being of such animals. Organizers of Jallikattu are depriving the rights guaranteed to the bulls under Section 3 of the PCA Act. Sadism and perversity is writ large in the actions of the organizers of Jallikattu, and the event is meant not for the well-being of the animal, but for the pleasure and enjoyment of human beings, particularly the organizers and spectators. Organizers of Jallikattu feel that their bulls have only instrumental value to them, forgetting their intrinsic worth. First limb of Section 3, as already indicated, gives a corresponding right to the animal to ensure its well-being. AWBI, a body established to look after the welfare of the animals, has to see that the person in charge of the animals looks after their well-being. We have no hesitation to say that Jallikattu, bullock cart race as such, is not for the well-being of the animal, and by undertaking such events, organizers are clearly violating the first limb of 3 of the Act. This is a very crucial. This is a finding of fact on the nature of the activity. This is not the repugnancy issue. This has got untrammeled blood, and that is the point that we were seeking to make. 36 blood. We will now examine whether the second limb of Section 3, which casts a duty on the person in charge or care of an animal to prevent the infliction upon an animal unnecessary pain or suffering, discharges that duty. Considerations which are relevant to determine whether the suffering is unnecessary, including whether suffering could have reasonably been avoided or reduced, whether the conduct which caused suffering was in compliance with any relevant enactment. Another aspect to be examined is whether the conduct causing the suffering was for a legitimate purpose, which is such as the purpose for benefiting the animals or the purpose of protecting a person, property, or other animal, etc. Duty is to prevent the infliction of unnecessary pain or suffering, meaning thereby no right is conferred to inflict necessary unnecessary pain or suffering to the animals. By organizing Jallikattu and bullock cart race, the organizers are not preventing the infliction of unnecessary pain or suffering, but they are inflicting pain and suffering on the bulls, which they are legally obliged to prevent. Section 3 is a preventive provision, casting no right on the organizers, but only duties and obligations. Section 3, as already indicated, confers corresponding rights on the animals as against the person in charge of care as well as AWBI to ensure their well-being and be not inflicted with any unnecessary pain or suffering. Jallikattu or bullock cart race from the point of the animals is not an event ensuring their well-being or an event meant to prevent the infliction of unnecessary pain or suffering. On the contrary, it is an event against their well-being and causes unnecessary pain and suffering on them. Hence, the 2 limbs of 3 of the PC Act have been violated while conducting Jallikattu and bullock cart race. Please come to just para 14, Lord. Pain and suffering are biological traits. Pain in particular informs an animal with specific stimuli it needs to avoid, and an animal in pain has pain receptors and a memory that allows it to remember what caused the pain. Please come to 41. Doctrine of necessity. 11.3 carves out exceptions in 5 categories of cases mentioned in 11.3a to e, which are as follows. But nothing in this section should apply to the dehorning of cattle or not castration. I've read these to your lordship earlier, so I don't need to repeat that. Exceptions are incorporated. Next page. Exceptions are incorporated based on the doctrine of necessity. Clause B to section 11.3 deals with the destruction of stray dogs out of necessity. Otherwise, it would be harmful to human beings. Clause D of section 11.3 deals with matters within chapter 4 incorporated out of necessity, which deals with experimentation on animals, which is for the purpose of advancement by new discovery of physiological knowledge or of knowledge which would be useful for saving or prolonging life or alleviating suffering of or combating any disease, whether of human beings, animals or plants, which is not prohibited and is lawful. Clause E to 11.3 permits killing of animals as food for mankind, of course, without inflicting unnecessary pain or suffering, which clause is also incorporated out of necessity. Experimenting on animals and eating their flesh are stated to be two more major forms of speciesism in our society. Over and above, the legislature, by virtue of 28, has favored killing animals in a manner required by the religion of any community. Entertainment, exhibition, or amusement do not fall under these exempted categories and cannot be claimed as a matter of right under the doctrine of necessity. Section 311 is already indicated, therefore confers no right on the organizers of Jallikattu or bullock cart race, but only duties, responsibilities, and obligations, but confer corresponding rights on animals. 311(1)(a) and A and O and other related provisions have to be understood and read along with 51 AG of the Constitution, which casts fundamental duties on every citizen to have compassion for living creatures. Parliament, by incorporating 51 AG, has again reiterated and re-emphasized the fundamental duties on human beings towards every living creature, which evidently takes in bulls as well. All living creatures have inherent dignity and a right to live peacefully and right to protect their well-being, which encompasses protection from beating, kicking, overdriving, overloading, torture, pain, suffering. Human life, we often say, is not like animal existence, a view having anthropocentric bias, forgetting the fact that animals have also got intrinsic worth and value. 3 of the PC Act has acknowledged those rights, and the said section, along with section 11A, 11 casts a duty on persons having charge or care of animals to take reasonable measures to ensure well-being of the animals and to prevent infliction of unnecessary pain and suffering. Para 43. All animals are not anatomically designed to be performing animals. Bulls are basically draught and pack animals. They are livestock used for farming and agricultural purposes like plowing, transportation, etc. Bulls, it may be noted, have been recognized as draught and pack animals in the Prevention of Cruelty to Draught and Pack Animals Rules 1965. Draught animals means an animal used for pulling heavy loads. The rules define large bullock to mean a bullock the weight of which exceeds 350 kg. Bullocks have a large abdomen and thorax, and the entire body has a resemblance to a barrel shape which limits the ability to run. Bulls also have limitations in flexing joints, and rigid, heavily built body and limited flexion of joints do not favor running faster. Due to the body constitution, the Prevention of Cruelty to Animals, Transport of Animals on Foot Rules 2001, especially Rule 11 says that no person shall use a whip or a stick in order to force the animal to walk or to hasten the pace of their walk. Bulls, it may be noted, are cloven-footed, 2-digit animals, and 2-digit in each leg can comfortably bear weight only when they are walking, not running. Horse, on the other hand, is a solid-hoofed, plant-eating quadruped with a flowing mane and tail, domesticated for riding and as a draught animal. Horsepower, as we call it, is an imperial unit of power equals to 550 foot-pounds per second. Horse's anatomy enables it to make use of speed and can be usefully used for horse racing, unlike bulls. Bulls, therefore, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of 3 and 11(1) of the PC Act. Chapter 5 of the PC Act deals with performing animals. Section 22 places restriction on exhibition and training of the animals, which reads as under. The point I seek to make is, these are scientific findings which are they have not been untouched, and the amendments do not take into consideration these scientific findings. The amendments simply carve out an exception to 3 and 11 to say that we will allow the relevant sports, and there is no concern or consideration to deal with these aspects. Now, kindly just see 48 and 49 for a moment. Lord, we'll just place 47 as well, Lord. The performing animals rules, because your Lordship had put that question on ticketing, define performing animal to mean any animal which is used at for the purpose of any entertainment to which public are admitted through sale of tickets, Jallikattu, bullock cart racing. Without sale of tickets, and hence 22 of the Act would not apply. So also the notification dated 11 July 2011, we find no substance or logic in that submission. It may be noted that when a bull is specifically prohibited to be exhibited or trained for performance, the question whether such performance, exhibition or entertainment is conducted with sale of tickets or not is irrelevant from the point of application of 3 and 11(1) of the PC Act. Then Lord 48, just read the portion below the provision quoted. 11(1)(m)(2) therefore says that if any person solely with the view to providing entertainment incites any animal to fight shall be punishable under the proviso of 11(1). In Jallikattu, a bull is expected to fight with various bull tamers for which it is incited solely to provide entertainment for the spectators by sale of tickets or otherwise. Inciting the bull to fight with another animal or human being matters little so far as the bull is concerned. It is a fight, hence cruelty. Jallikattu, bullock cart race, therefore violate not only 311(1)(a)(m) and section 22, but also the notification dated 11 July 2011 issued by the central government under 22(2) of the PC Act. I may just add not that notification is still in force. We may, 49, we may in this connection also refer to the performing animal registration rules. Rule 8 deals with the general conditions of registration. Rule 8(1)(5) states that the owner shall ensure that any animal is not inflicted unnecessary pain or suffering before or during or after its training or exhibition. 8(1)(7) specifically cautions that owner shall train the animal as a performing animal to perform an act in accordance with the animal's natural instinct. A bull is trained not in accordance with its natural instinct for the Jallikattu or bullock cart race. Bulls in those events are observed to carry out a flight response, running away from the crowd as well as from the bull tamers. Since they are in fear and distress, this natural instinct is being exploited. But in fact, there was an affidavit at that state filed at page para 50, and the relevant portion is from the AWBI. Please see the quoted portion. I affirm on behalf of the Animal Welfare Board of India that Jallikattu is indeed an extremely cruel and barbaric sport in which bulls are forced to participate, are brutalized and subjected to unnecessary pain and suffering. Surrounded by huge crowds of screaming, shouting people intent upon them, cruelly subdued and overpowered, regardless of what they endure, the bulls are subjected to terrible acts of cruelty. Then Lord, beaten, kicked, chili powder, etc., rubbed into the eyes. All of this, I don't want to just come to the italicized portion. Just 3 lines above that. By no stretch of imagination can bulls be termed as performing animals or trained for the sport. In fact, what occurs during the event is that the participating bulls are forced to endure unnecessary pain and suffering beyond measure. It is for this reason that the answering respondent had represented to the central government that this barbaric prehistoric event masquerading under the guise of sport be banned. Then what there is more about the other act, I won't trouble.
Siddharth, our request. After the amendments are made subsequent to this judgment which you are reading to us, all the 3 states are very conscious. Section 3 of the Act, Substantive Act, is 60. They have come out with rules. Taking section 11 and section 3 put together, cruelty is defined.
Yes.
And how the safety of animal can be there.
Yes.
They have prescribed certain rules.
Yes.
Now, this is a balancing between the two. There should be no cruelty. At the same time, they may continue with their long festivals and traditions that they are following in the respective states. Now, our question to you is, when this court was examining this judgment which you read to us, what were the rules? Is the rules as the state have now come forward prescribing in the respective states? The same rules were there at a given point of time under the 60 Act.
But what they did was when they, no, Lord, I must tell your Lordship, under the 60 Act, these sports were not permitted. Then they come in with the state amendment, the TNRG Act, not which the state law comes in. And essentially, I've got that comparison. It's not really similar. There's no real, just keep.
All the 3 states took assent from the president.
No, Lord. I'm sorry, Lord.
All the 3 states with their state amendment took assent from the president.
Yes, Lord.
And for the safety or other purpose of the animals, they have come out with their rules
Yes,
as to how it has to be implemented and regulated.
yes. And those are not, if I may say so, what was dealt with in Nagaraj and what is now sought to be brought in as so-called safety measures is really similar, Lord. There is no real change. It's just that now the path is a little different. It's a little more sophisticated, but sophistication may not alone save it, Lord, because the question will be, and this is another issue which your Lordship will deal with. What was placed before the President? Were these issues placed? Because that aspect, while President assent is one issue, not, but that aspect your Lordship will look at and see. They have only given us one document, and I'll just show your Lordship that one document they've given us. Just show that one document, because we have tried to understand as to what was placed. All they do is for Maharashtra, and I'll just give your Lordship the page number. The convenience compilation by Maharashtra, annexure A11 at page 38, just says that, just as the letter saying, state government's letter on the subject to return to authenticated copies with the president's assent, nothing mentioned. And it's described as the presidential assent, no details as to what was sent to the president, because that becomes very crucial. Your Lordship has now brought in series of decisions said, when you want to overcome a situation, whether it be by way of a judgment of this court or otherwise, and you're bringing in a legislation, you're bringing it, and you're seeking presidential assent, you will have to say, what is it that, what purpose was sought to be, what was the purpose that was placed before the president? And that aspect is completely silent on that. Just one line, presidential assent granted. We don't know whether they'd explained the contours of Nagaraj to the president, they placed the contours of Nagaraj as also the findings of fact. And even since your Lordship raised the issue of cultural rights, I was just going to take you straight to para 53 of Nagaraj, which deals with the issue of culture. So not even for culture, there will be two parts. One, Nagaraj deals with it. Secondly, on culture, there is no finding, there is no material placed by them at any point of time to justify then or now, to justify that this is part of culture. Because eventually, not if you take an argument, this is a cultural right.
That can't be open for us.
But your Lordship has seen it. But is it not your Lordship? Not, I'll place the law.
Legislative competence.
Not your Lordship. No, your Lordship will consider whether something is part of culture. Not, for example, and I might say this not. I'll give your Lordship the example straight away. Not for example, and I'll give the example. Not Sati, for example, was supposed to be part of culture. Legislation came in. There have been other issues which are stated to be part of culture, but they have to prove a cultural practice. They have to establish that cultural practice, and that's the law. Not the Dowry Prohibition Act came in. Not at one point, dowry was supposed to be part of culture. The legislation came in. Child marriage was done away with. Widow remarriage was done away with. The law.
These were all through legislative process.
But they were through legislative processes. But the point
This is not the,
my lord,
on judicial process.
my lord, I appreciate. Not today. All I'm pointing out to your Lordship is, while you're looking at it in a judicial process.
Indictment tomorrow legislature says that this is prohibited, we have nothing to.
Not, it's like this. It's not, I completely understand. It's like this, not, does it lie with a citizen or section of citizens to claim that something is their right? And if the legislature says that something is accepted as a cultural practice, our case is, there has to be the existence of a cultural practice to accept it. A mere activity does not gain the status of a fundamental right or part of Article 29 rights merely because it is an assertion. That will have to be tested by your Lordship, because today we are saying there is no basis to say it's a cultural right. And
You are inviting us to test the legislative wisdom.
no, Lord.
That is a risky.
No, Lord. I'm inviting your Lordship to test it in line of the question framed on 29, whether this is protected under 29 or not. Now, that is a question which has been framed, which I hope your Lordship will consider answering. And in that context, not just come back to Nagaraj at para 53 for a moment.
Whole Nagaraj you have read over to us.
I'm sorry, Lord.
The whole Nagaraj judgment you have read.
No, Lord. There are a couple of things.
Para 53 is,
But since one of the questions is framed on Nagaraj, Lord, I'll have to place it.
para 53 you want to gives trust to that to show that what was the practice or as part of the culture is
Yes,
different.
Yes. No, Lord,
That is totally different.
Yes, Lord. So, Lord, there are two parts to it. 53 says that, 53, 54, and then 55, Lord, and 56. And I'll just read these four paras. The statements and objects and reasons of the TNRG Act refer to the ancient culture and tradition and does not state that it has any religious significance. My Lord Justice, so we have para 53, Lord, at page 589 of the report. Your Lordship sees it. Even the ancient culture and tradition do not support the conduct of Jallikattu bullock cart race in the form in which they have been conducted at present. Welfare and well-being of the bull is Tamil culture and tradition. They do not approve of infliction of any pain and suffering on the bulls. On the other hand, Tamil tradition and culture are to worship the bull, and the bull is also considered as the vehicle of Lord Shiva. Yeru Kazuvu in Tamil tradition is to embrace bulls and not overpowering the bull to show human bravery. Jallikattu means silver or gold coins to the bull's horns. And in olden days, those who got the money to the bull's horn would marry the daughter of the owner. Jallikattu or the bullock cart race as practiced now has never been the tradition of Tamil Nadu. The PC Act, a welfare legislation in our view, overshadows or overrides the so-called tradition and culture, Jallikattu and bullock cart races, the manner in which they are conducted. Yes, sir. Yes, what I was saying, Jallikattu and bullock cart races, the manner in which they are conducted, have no support of Tamil tradition or culture. Assuming it has been in vogue for quite some time, in our view, the same should give way to their welfare legislation like the PC Act, which has been enacted to prevent infliction of unnecessary pain or suffering on animals and confer duties and obligations on persons in charge of animals. Of late, there have been attempts at certain quarters to reap maximum gains, and the animals are being exploited by human beings by using coercive methods and inflicting unnecessary pain for pleasure, amusement, and enjoyment. We have a history of doing away with such evil practices in society. Assuming such practices have the support of culture and tradition as tried to be projected in the TNRG Act. Salmon states that custom is the embodiment of those principles which have commended themselves to the national conscience as to the principles of justice and public utility. This court in Adityan, while examining the scope of Articles 25, 26, 26b, 17, 14, 21, held as follows. Quote, any custom or usage, irrespective of even proof, any proof of their existence in pre-constitutional days, cannot be countenanced as a source of law to claim any rights when it is found to violate human rights, dignity, social equality, and specific mandate of the Constitution and law made by Parliament. No usage which is found to be pernicious and considered to be in derogation of the law of the land or opposed to public policy or social decency can be accepted or upheld by courts in the country. But that was the case, if I may remind your lordships, where the issue was whether a non-Brahmin individual could be a priest in a temple. And the question was that a person is to be a person of learning. And they said there is no such permission in the law, in the customs. In as early as 1500 to 1600 BC, in Isha Ushpanits, it is professed as follows. The universe, along with its creatures, belongs to the land. No creature is superior to another. Human beings should not be above nature. Let no one species encroach over the rights and privileges of other species. In our view, this is the culture and tradition of the country, particularly the states of Tamil Nadu and Maharashtra. The PC Act has been enacted with an object to safeguard the welfare of animals and evidently to cure some mischief and age-old practices so as to bring into effect some type of reform based on eco-centric principles recognizing the intrinsic worth, value and worth of the animals. All the same, the act has taken place of certain. About State Article 73, 71. 71 at page 595. We have, however, lot of avoidable non-essential human activities like bullock cart race, Jallikattu, etc. Both thinking that they have only instrumental value are intentionally used though avoidable, sick, non-essential human activities, ignoring welfare of the bull solely for human pleasure, Such avoidable human activities violates rights guaranteed to them under 3 and 11 of the PC Act. AWBI expert body has taken up the stand that events like Jallikattu, bullock cart race inherently involve pain and suffering, which involve both physical and mental combination distress. Then, Lord, there's a quotation from a judgment from a book which says, single worst thing you can do to an animal emotionally is to make it afraid. Fear is so bad for animals, I think it is worse than pain. I always get surprised looks when I say this. If you give most people a choice between pain and fear, they'd probably pick fear. Both anxiety and fear therefore play an important role in animal suffering, which is a part and parcel of events like Jallikattu, bullock cart race. Now, not the right to life argument, 72. Every species has a right to life and security subject to the law of the land, which includes depriving its life out of human necessity. Article 21 of the Constitution, while safeguarding the rights of human life, has been good. And any disturbance from the basic environment, which includes all forms of life, including animal life, which are necessary for human life, fall within the meaning of 21 of the Constitution. So far as animals are concerned in our view, life needs something more than mere survival or existence or instrumental value for human beings, but to lead a life with intrinsic worth, honor and dignity. Animals' well-being and welfare have been statutorily recognized under 3 and 11 and the rights framed under the Act. Right to live in a healthy and clean atmosphere and right to get protection from human beings against inflicting unnecessary pain or suffering is a right guaranteed to the animals under 311 of the Act, read with 51 AG. Right to get food, shelter is also guaranteed right under 311 and the rules framed thereunder, especially when they are domesticated. The right to dignity and fair treatment is therefore not confined to human beings alone, but to animals as well. The right not to be beaten, kicked, overridden, loaded is also right recognized by 11 read with 3. Animals also have a right against human beings not to be tortured and against infliction of unnecessary pain or suffering. Penalty or violation of these rights are insignificant since laws are made by humans. Punishment is not commensurate with the gravity, hence being violated with impunity, hence the necessity of taking disciplinary action, etc. 73. Jallikattu and other forms of bull's race, as the various reports indicate, cause considerable pain, stress and strain on the bulls. Bulls in such events not only remove their head, showing that they do not want to go to the arena, but as pain inflicted in the Vadi Vasal is so much, they have no other go but to flee to a situation which is adverse to them. Bulls in that situation are stressed, exhausted, injured and humiliated. Frustration of the bulls is noticeable in their vocalization and looking at the facial expressions of the bull. Ethologist or any ordinary man can easily sense their suffering. Bulls otherwise are very peaceful animals dedicating their life for human use and requirement, but they are subjected to such an ordeal that not only inflicts serious suffering on them, but also forces them to behave in ways they do not behave, force them into the event which does not look like, and in that process they are being tortured to the hilt. Bulls cannot carry the so-called performance without being exhausted, injured, tortured, or humiliated. Bulls are also intentionally subjected to fear, injury, both mentally and physically, and put to unnecessary stress and strain for human pleasure and enjoyment, and that to a species which has totally dedicated its life for human benefit out of necessity. We are therefore of the view that 21 and 22 of the PC Act and the relevant provisions have to be understood in the light of rights conferred on animals under 3 read with 11(1) A and O and Article 51 G and H, and if so read in our view, bulls cannot be used as performing animals for Jallikattu and bullock cart race, since they are basically draught and pack animals not anatomically designed for such performances. However, this was the essence of the Nagaraj judgment, and our submission is Nagaraj recognizes the right of animals to be kept in a safe environment. It says it's definitely a right by legislation, but it then relates the legislation to constitutional provisions. And my respectful submission, I don't need to, it's like taking coal to Newcastle, but just two illustrative decisions, Lord, on directive principles to be read into fundamental rights. I just place those two decisions. One is Minerva Mills and a few paras, Lord, of state that
that Gujarat, Mirzapur, Moti, Qureshi Kasar case. I'll just come to lot 2005 8 SCC 534 because that will cover the Minerva bill principles. Yes,
See, as a principle, directive principle, and fundamental rights are interrelated, or directive principles may be on a higher plane sometime. That we have no problem in
yes, no.
accepting.
Yes, no.
But
So not the context.
51AG is also clear.
Yes, no.
Article 21, is there any other precedent?
No, I
Or
was,
was there any debate in the Constituent Assembly that this shall extend to the animals or anything like that? Or is it coming here for the first time?
but if I may say so, Lord, we had in the constitutional review the provisions regarding the protection of cow produce. That to that extent there was a debate. Lord.
To that extent, there was a debate in relation to,
No, cow protection, they need to wait into directive
that was there,
principle.
that was there. Now, not the only thing that your lordship will see is in this decision, because this Mirzapur case interestingly deals with cows and cow progeny lot, and this was, your lordship recalls that case in relation to slaughter lot and the animal preservation
Is
list.
there any authority before this in which it has been held that an animal is entitled to protection under Article 21?
But I would say that not really from the Supreme Court, there are a number of High Court decisions prior to this, and then there are subsequent decisions also which have followed Nagaraj. I got those, just give me that.
No, pre-Nagraj.
Pre-Nagaraj, there are decisions of different High Courts, but those are there.
Oh.
I'll just tell you.
Give us the passage and
I'll give your lordship, Lord. But they are pre-Nagaraj. I'll tell your lordship the decisions are, if I may just point out, if you're kind enough just to see volume 1 of the compilation of judgments, just have a look at the index straight.
Clear about that.
because if Article 21 cannot be invoked for protection of animals, then Minerva Mills and that line of authorities become redundant so far as this
Lord,
litigation.
I will show your lordship in I'll show your lordship, there's some passage in Mirzapur Motikasa which will be important, but we'll come to that. That's why I'm saying this follows Minerva. But your lordship put a question to me, please see the index, Lord. Serial number 10 onwards, volume, serial number 10 in the index, Lord. Just have a look at the index. Compilation of judgments.
Yes.
Lord, serial number 10 onwards. This is the decision, Lord, Gujarat High Court 2012. Lord, there's a heading analysis. It deals with the analysis. At page 472 of the compilation. Then, Lord, then you'll have serial number 11, para 805 and 8.05, 8.06. Gujarat High Court again.
No, this
Yes.
analysis, what is the 21 point?
Lord,
Article
there is
21.
there's no specific reference to 21, Lord, but there were judgments which recognize rights of animals.
The rights of the animals, statutory right. There's no
It's what is
dispute on that.
51 AG, Lord. Lord, but there is one line there, Lord, without specifically referring to 21. Does your lordship have? I'll place that just a moment. Does your lordship have that?
Which one?
Lord, if your lordship looks at page 472,
Yes. That analysis.
yes, Lord, second para, without referring to 21 specifically, using the saying to 21, it says, we are considering this matter from a little wider horizon. Cattle, like human beings, possess life in them. Even an animal has the right to say that its liberty cannot be deprived except in accordance with law. Then we have noted that there are many enactment decisions recognize rights of animals. Then 51A comes just above the Supreme Court decision.
So on 21, there is no authority really before this.
So, Lord, if I may just say, not specifically referring to 21, Lord, there will be again at 482 passages not regarding birds, 805 and 806.
They are like human being, all the migratory birds will require visa and passport.
And then, my Lord, there will be the judgment. There's not 805, 806, and my Leonard, please point out 811. No, 811 is only the definition one. Yes, Lord. 811, Lord, about the sixth line from the top. As stated above, every bird animal has a right to move freely. It cannot be disputed that so far birds are concerned, they have a right to move freely in the open air. Then, Lord, there is a judgment. For judgment is also there. Lord, this is Kerala, Lord, which your Lordship will see, and para 13. Before para 13,
Para 30,
13, Lord, 13.
the Goa judge.
No, Lord, this is, Lord, I'm not your Lordship will be looking at. Goa, Lord, that's Goa judgment is para 7. That's Goa judgment is para 7. But that Goa judgment is the one, Lord, which I have told your Lordship. I'm sorry. Wait, just a moment, Lord. I'm sorry, I've got. Just a minute. Yes, but Goa judgment is, I'm sorry, 505, my mistake. 11 and 13. Same reasoning, Lord. Para 11 talks about cruelty at page 509. Para 13 talks about bullfights and how they are cruel and how animals are injured and have to be put to sleep because of this. This is in the context of bullfights. And please see 21, Lord, para 21 of this judgment. The Goa judgment. Is the Lordship of 21 at 512? That's the closest note to 21 rights. It cannot be disputed that all animals are born with an equal claim for life without any cruelty to them. Perhaps if this right was given proper recognition by human beings, there would have been no necessity to bring a statute book the Act. Unfortunately, even though the Act has been brought in force, there still appears to be lack of courage or negligence, and therefore, in our consideration, petitions are justified in making a grievance of the same. So, that is the clauses where it talks about. All of them will mention the life, the right to live with dignity of animals, but they don't specifically refer to 21. But to that extent, 21 is referred. But one more thing, my learned colleagues want me to place is 497, the NR Nair judgment. Para 13 at 497.
No person should be deprived of his life.
Housed in cramped cages, subjected to fear, hunger, pain, not to mention undignified way of life that they have to live with no respite. Impure notification has been issued in conformity with the changing scenario. Values of human life, philosophy of the Constitution, prevailing conditions, surroundings, circumstances to prevent unnecessary pain. Though not Homo sapiens, they are also entitled to dignified existence and inhumane treatments from cruelty and torture. This has been upheld by the Supreme Court at page 499. In para 11, if your lordships do in NR Nair law, para 11 at 503, and if your lordship looks at classical C, that apart, it is the welfare of animals which is of paramount consideration. And it is only if the government is satisfied on the basis of materials that unnecessary pain or suffering is inflicted in course of training at the time when it is exhibited that it needs reading of the Act 2 lines below, reading of the Act as a whole shows that 22, the necessity for the government to come to conclusion that if a notification under the section is not issued, there would be unnecessary pain or suffering in training or execution. The existence of fact is a precondition to existence of notification. But that was in relation to surfaces. So these are all pre-Nagaraj decisions. There are a number of post-Nagaraj decisions as well, Lord, and those are also part of the compilation, but they really follow Nagaraj.
That's okay.
Mr. Luthra,
Yes.
before you proceed away from Nagaraj, certain physical attributes of the bulls were mentioned in paragraph 43 by Justice Radhakrishnan.
Yes.
Now, are you assuring this court that bulls have not embraced any of the latest fashion trends of trying to be slim or, are you assuring this court of that? That since 2014, bulls have not caught on to the trends of today?
But if they have, then in the,
You don't have to give a serious answer.
but I must tell your lordship, not on a lighter note, Lord, I have not been able to be slimmer, Lord, so I'm sure the bulls are not that successful either. I'm trying, but I'm not achieving it.
These two people are
534 decision, Lord, which is at page 177 of that, of the compilation.
Yeah. Just 1 minute. The Prevention of, the PC Act, ACA Act 1960, it defines animal to A. It means any living creature other than a human being.
Yes,
Other than a human being.
yes, my lord.
And now come to Article 21.
Yes, my lord.
No person shall be deprived. And the next word, his life.
Yes, my lord.
So, do you mean to say that his should be taken as the life of these animals also? How will you connect this with, especially in the light of the definition 2A?
My lord, therefore the argument.
It means a human being totally excluded. And now 21, how you will
But in fact, not, but I appreciate what your lordship says, Lord.
because it only says no person shall be deprived of his life or liberty, except in accordance according to the procedure established by
Very
law.
true, Lord.
How
We correlate the two? Number, the answer is, to my mind, not very straightforward. By an interpreted process, your lordships have recognized the personhood of animals. It is not that your lordship says that animals are meant only for the use of human beings. There is a line of use, as culminated in Nagaraj, that we have changed from an anthropocentric, that is the human-oriented approach of legislation, of looking at the of environment, of looking at animals, looking at wildlife, to an ecocentric approach where we look at the focus of what is
To say that they got a right under section 3 of this act, that's something different. But how will you put it under 21?
that we are bringing in through, that we seek to bring in through, so the purpose of personal through Lord 48, 48A and 51, and that was the decision not in Muhammad Salim's case by the Uttarakhand High Court. May I just place that for your lordship's consideration? That is not in volume 2. Volume 2. Serial number 18. Serial number 18 at page number 684, and kindly look at relevant page being, my lord, para 689, para 14 first will read. Para 14. Not para 14 at 688. Is your lordship at 688?
Yes.
But 688 will quote a judgment, and I read that portion, then I'll come to the relevant para. In 2004, volume 4, SCC 146, their lordships of Honorable Supreme Court in the case of Shiromani Gurdwara Prabandhak Committee Amritsar versus Shri Somnath Das have held that the concept juristic person arose out of necessities in the human development recognition of an entity as a juristic person is for subserving the needs and faith of society. Then Lord, it quotes para 11, and I will bring your lordship straight away to para number 14 of the quoted portion at page 689 bottom. This is what I must say is pending consideration and stayed by your lordship, but I am placing it. Thus, it is well settled and confirmed by the authorities on jurisprudence in courts of various countries that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person became inevitable. This may be an entity, living, inanimate objects or things. It may be a religious institution or any useful unit which may impel the courts to recognize this. This recognition is for subserving the needs and faith of society. A juristic person, like any other natural person, is in law also conferred with rights and obligation and is dealt with in accordance with law. In other words, the entity acts like a natural person, but only through a designated person whose acts are processed within the ambit of law. But then it gets into juristic persons, idols, etc. Please come straight away to para 16. That was the quoted portion of Gurdwara Prabandhak Committee, but para 16 now. The development of society, where interaction of individuals fell short to upsurge the social development, the concept of juristic person was devised and created by human laws for the purpose of society. A juristic person, like other natural person, is in law also conferred with rights and obligations and is dealt with in accordance with law. In other words, the entity acts like a natural person, but only through a designated person. As the lordships have held in the judgment cited above, that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person becomes inevitable. This may be an entity, living, inanimate objects or things. It may be recognized religious institutions or any such useful unit which may impel the court to recognize it. The recognition is for subserving the need and faith of society. Corpus Juris Secundum, Volume 6, Para so-and-so explain the concept of juristic persons, artificial persons thus. Artificial persons such as are created and devised by human laws for the purpose of society are called corporations of already reported. Juristic person can be any subject matter other than a human being to which the law attributes personality for good and sufficient reasons. Juristic person being the creation of the law, as many persons have been created by law, as society requires for its development. Thus, to protect recognition and faith of societies, rivers Ganga and Yamuna are required to be declared as legal living persons. I must point out, this decision has been stayed by a Lordship's court, it's pending in another bench, but this is my duty to place that. But it relies upon Shiromani Gurdwara Prabandhak Committee, which said that you can have, in that case, not the Holy Guru Granth Sahib was held to be a juristic person. The point I seek to make is that personhood is no longer limited limited under the Constitution merely to human persons under 21. The point that is to be made is not when animal life and the environment is inalienably connected to us, and therefore we are not whole without it. The protection of that part of life also becomes essential. The avoidance of cruelty to that part of life is also, and today in Nagaraj, as I said, your lordships have recognized that right as to how rights exist in animals not to be prevented cruelly, and use the DPSP and the fundamental duties to read into 20.
Some of the European jurisdictions possibly recognize river, and I think there is one judgment of a New Zealand court, possibly.
Yes, sir. But in fact,
Then the lawmakers should be left with that exercise.
But-
Why should we
not the question today is,
venture into that territory?
no, we are not asking your lordship to venture into the territory. The question today we are doing is testing whether the law is valid or not.
Yes, that's the only scope of inquiry so far as us are concerned.
Yes. Yes, but that is something about which your lordship is looking at it from the perspective of whether it is legitimate or not. And therefore, that is the test. But in fact, lordship just looks at 671 in that compilation note, which is part of the Guru Granth Sahib judgment. Just have a look at that for a moment. 661 and 671.
Ganga Yamuna juristic person है.
There is a reference to Saman. It deals with other than human persons. A legal person, para 16, is any subject matter other than a human being to which the law attributes personality. This extension for good and sufficient reasons of the conception of personality beyond the class is one of the most noteworthy feats of legal imagination. Then overly flawed. Para 17, jurisprudence by pattern says it is already been asserted that legal personality is an artificial creation of the law. Legal persons are all entities capable of being right and duty-bearing units. All entities recognized by law as capable of being parties to a legal relationship. Saman said, so far as legal theory is concerned, a person is any being whom the law recognizes as capable of rights and duties. Then Lord 18, and I'll read 18. Analytical and historical jurisprudence describes person. We may therefore define a person for the purpose of jurisprudence as any entity, not necessarily a human being, to which rights or duties may be attributed, as in our case, not rights and duties are attributed. 19. Thus, it is well settled and confirmed by authorities on jurisprudence and courts of various countries that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person became inevitable. This may be any entity, living, inanimate, object or thing. So any entity living, inanimate, object or thing. Now, that's the view your lordships have taken in terms of juristic personality or personhood. And our submission is that we cannot deprive animals and animals to whom various protections have been considered, accepted as part of the constitutional framework, as also under specific legislation, to be out of it. I'm not in this.
Siddharth, I can tell you only one thing,
Yes,
at least for myself.
yes, of course.
So, yeah, these all surroundings going on. You are not able to know what is your thrust of submission. Because what I'll tell you myself, we were also interested. After Nagaraj, every state consciously made certain amendments,
Yes.
which I put to you earlier also.
Mhm.
And if you see section 3 of the Act of 60
Yes.
and section 11,
Mhm.
section 3 and the object also,
Mhm.
it only relates to prevention of cruelty to animals.
Yes, madam.
Okay.
Yes, of
Now
course.
come to section 3.
Yes.
It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal unnecessary pain or suffering.
Yes, ma'am.
Now, section 11.
Mhm.
Certain amendments have been made under section 11
Mhm.
under the State Act,
Yes, my lord.
and to cover up section 3, they have framed certain rules.
Yes, ma'am.
What preventive measures had to be adopted by respective states in reference to the animals in question for the purpose of their culture and all, to make a balance. And these rules have been framed under the guise of this section
Yes,
3.
yes, ma'am.
But my question to you is that if there is a breach of any rule
Mhm.
prescribed for maintaining and upholding this cruelty to animal in any culture which they organize or their festival, that is not the question to us.
No, that's not the issue.
The question to us is such an amendment made? How this provision is unconstitutional?
But I'll come. But
So our question to you is, if the state legislature is wisdom balancing to continue with their culture also and the safety of animals also, prevention of cruelty also, so according to you, what is the constitutional, you're questioning the validity of this provision in question?
not two things. Not 114.
Because Ganga and Jamuna is not going to
No, no,
touch it here.
no, Lord. I was responding to the query
Yes.
as to personhood, Lord, since my Lord is.
We agree with you on the substance.
Lord, now the only issue, Lord, here is straight away. Our case is that it's a clear case of arbitrariness. You cannot have you cannot have an amendment, so to speak, which will nullify the purpose of the main act. Now,
Now,
would it-
just
would it
come to
straight-
this.
Lord, come straight
Come to
away
this, straight away.
come straight away to Kameshwar Singh, Lord, which is 1952. One is,
No, Mr. Siddharth, we'll come to judgment later.
yes,
Don't go 52.
Yes.
Come hit straight away how this is abuse of discretion with the legislature wisdom exercise.
but I'll straight away show you.
Demonstrate first.
Your Lordship's got this chart.
And as you give it to us,
Now, Lord, let's look at this. Now, Lord, kindly see.
demonstrate to us straight away.
Come straight.
Yes, we have a chart.
Now, Lord, come straight away.
Yeah, that's.
Siddharth,
That's the one, Lord. That's the one. Now, Lord, kindly just see for your Lordship's convenience, what we've done is, because the other legislations were not there at the time of Nagaraj.
that's good.
So for convenience, we put not the Regulation Act, which is under question in Nagaraj, in the first column, then the 2017 Act and the rules. Does your Lordship have it?
Yes.
Now, kindly just note, in the definition clause, note is similar. in the earlier act and the current act? Does your lordship have that?
Yes, we have it.
Now please come to 3. Now please keep in mind, 3 casts, as your lordship has noted, certain duties. Now see how they have sought to amend 3. Now 3, not there is an amendment which they make. In the original act, the Tamil Nadu Act, not they had said, they had put in certain issues. All of these, every one of the bulls participating shall, in the event, to the authorities of the Animal Husbandry Department for testing, etc. 2 will be certificate. C will be no performance enhancement drugs. D will be the duties. Now, all of this has not come in section 3 of the original act, the Tamil Nadu Act, but has now been placed in the rules. The safeguards will come now in the rules in the right column. But please see what 3 does in the middle column. And I'm going to read it in its entirety. It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. 2, notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to rules and regulations as be framed by the said government shall be permitted. Now my submission is this. There is now a finding of fact which is untrammeled that Jallikattu per se, sports races involving bulls, keeping with the anatomical nature of the bulls, as my Lord Justice Roy said, they may not have lost weight in the last 8 years. All of that work is something which has been found and determined by your lordship. Today they say, we will allow these sports, whether Jallikattu, Kambala or the race or the exercises, bullock cart races in Maharashtra, and in effect nullify the first part of the section 3. And how do we do it? We bring in these rules which could not have even been before the president because the rules came later. So these rules are safeguards which they see, safeguards that they bring later. Now, Lord, please then come to, on the 4th page, section 11 is there. In section 11, Lord, they have, those were the exceptions, Lord, section 11. As to section 11, see what will not be done. Then, Lord, there's 22. And section 11, kindly note overleaf, they will say in italics, F has been added. And I'm just using the Jallikattu example, all others are similar. The conduct of Jallikattu with a view to follow and promote tradition and culture and ensure preservation of native breeds of bulls as also their safety, security and well-being. Now, I put it to your lordship, Lord, the exceptions were specific in the central legislation. And what are they illustrated? Look at B. Destruction of stray dogs in lethal chambers, extermination of any animal under the authority of law for the time being in force, but such as the Wildlife Act when you want to cull an animal. Any matter dealt with in chapter 4, which is scientific testing. E. The commission or omission of any act in the course of destruction of the preparation as food for mankind, unless destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. So, proportionality and necessity, yet you bring in a simple thing, conduct of Jallikattu with a view to follow and promote tradition and culture, ensure preservation of native breeds of bulls as well as their safety, security and well-being. Now the question to be asked is,
and also the experience on animals.
how are you going to
It's not permissible.
compare, you say there are bulls which do racing, you say there are bulls which are meant as draught animals and for breeding. What is this exception that you have sought to create?
One thing, always the legislature, they understood and recognized the life of a human being, the life of an animal differently.
Yes.
Say for example, whether mercy killing is permissible or in the case of human beings.
But now in terms of the common cause, your lordship has allowed it to be done. And I must also point out, since your lordship has raised a very important issue, Lord, under the 2002 medical rules, not medical ethics rules, under regulation 6.7, a person who is in a certain brain dead state, vegetative state, a committee of doctors, even under the subordinate legislation, can actually, in effect, take off life support. Not that's regulation 6.7.
But then come to 13.
Yes, but 13.
13 and 14, in that sense, they are relevant.
But
You come to 13,
yes, of course.
see, if
14, yes, but 13.
13 and 14,
Yes, of course not.
14, it permits experiments on animals.
Yes, of course it does.
That is permissible.
And not, please see the purpose. Please see the purpose for a moment.
We are only saying that the legislature, how they view it. So 14 is there and 13 also. The only thing is that if it would be cruel to keep the animal alive, if that is the belief, then of course you can.
My lord, I must tell your lordship, even in the case of human beings, your lordship has permitted regulated clinical testing on human beings. So human trials are permissible. It's not that they're
See
not.
the difference between these two, 13 and 14.
But I completely understand.
When it comes to the case of human beings and when it comes to the case of the animals,
Yes.
so the legislature thought it very carefully and put them in different vessels.
Lord, if I may say so, Lord, so far as 13 is concerned, please also then consider 12. 12 says cruelty not to be permitted, Lord, it provides for specific practices. Now, if your lordship says, if this is the swan song of this legislation, then my respectful submission will be the exception carved out for sports is a matter of entertainment. 13 is to prevent further pain and suffering to an already injured animal. Lord, the similar example in the case of human beings, though it's much more narrower, because there the considerations become somewhat different, are, as I said, regulation 6.7 and the common cause judgment, whereby your lordship allowed for people to be taken off life support through the living will process. Having said that,
13 and
14, Lord, also consider this 14. 14 says, nothing contained in this act shall render unlawful the performance of experiments on animals for the purpose of advancement by new discovery of physiological knowledge or of knowledge which will be useful for saving or for prolonging life or alleviating suffering or for combating any disease. Now see, whether of human beings, animals or plants, the doctrine of necessity. So Lord, all I'm saying is, this is the doctrine of necessity, which is a known carved out exception. We are dealing with a non-essential thing.
Distinction has been made.
Lord, if it was an
So 14, if it is for the purpose of advancement of or discovery of or for the welfare of the human beings, then it is permissible.
or animals, not or animals, or animals or
14.
plants, or animals or plants. Please see that it says all three. No? It says all three. It says for combating any disease, whether of human beings, animals or plants. So the point I seek to make is not, there is the doctrine and the principle of necessity. So far as necessity is a recognized statutory exception that has been made. And that exception cannot then be treated at par, and that's where the arbitrariness will come in. It cannot be treated at par or as a sport for the purpose of human joy or fun or entertainment. We can't, Lord, and that's where I would say, Lord, that exception cannot be applied to create such exceptions of the like that are sought to be done.
All these were put when you actually made an attempt to say that Article 21 is available.
Yes, Lord.
Initially you attempted to canvass the position that Article 21 is available to animals also. That is why we put all these.
Yes, of course. Yes, of course. But I've sought to argue that and place it before your lordship for your lordship's consideration. Now, Lord, I'll just come to manifest arbitrariness after that. But if your lordship just sees, as my Lord Justice Rastogi put it to me, Lord, please see the exceptions that are contained, Lord. All of this is really an exercise which is to replicate the TNRG Act through another legislative mechanism. That is the sum total of it. Now, Lord, if I may just take your lordship now to the argument that we were seeking to make on arbitrariness, Lord, because that is one aspect which I will have to place at some length. And Lord, multiple decisions, but I'll just place Shaira Banum, Lord, and kindly just see that's at volume 5, page 887.
This is
Volume 3, page 887.
that is why they define animals other than human beings without any code box. That is why they define the sex.
Pause. Lord, I will also place before your lordship on us, before Lord we come to the next part, certain foreign judgments, Lord. There's the monkey case from Ecuador, and there is a court from in relation to chimpanzees from Argentina, Lord. Those we have the relevant paras, which recognize their rights, because your lordship on the last
What
occasion.
are on the simian species?
But it's not so far, those are the ones we found. There are others, but the translations were not easily available. So we are not able to decipher what is the ratio of the decision. Lord, we'll place those, Lord. One is from Ecuador, and one is Constitutional Court of Ecuador, and one is from Lord, the Court of Guarantees in Argentina. Now, Lord, the point that I have been trying to canvass to your lordships is this. When a legislation talks of cruelty and prevention of cruelty, and the amending acts perpetuate what we state as cruelty, then the two cannot go together. I will just leave with your lordship the one line from Kameshwar Singh, Lord, which is,
Oh, kindly repeat the proposition.
but I'll just tell your lordship straight away. When the legislation and the legislative entry talks of prevention and protection against cruelty, we cannot have amending acts which perpetuate cruelty. In this context, kindly just make a note of one para in Kameshwar Singh. Lord, there were three judges who said the same thing, but there is a very interesting sentence, Lord, in this regard, because one of the issues that was raised was the colorable nature of the legislations. This was in the context of, Lord, the Land Reforms Act. And as your lordship would have noted, not interestingly, none other than Dr. Ambedkar had argued the matter on some of the cases.
UP Zamindari
Yes,
Association.
not, yes, not all the Zamindari Acts and Land Bihar Land and other land reform acts. Now, but here the issue was in relation to the entry of entry 36 of acquisition or requisition of property, Lord, except for the purposes of list 3 entry 42, and list 3 entry 42 was compensation which could be given for properties acquired, etc. And whether the power was validly exercised. Now, there is not just a very important line which I will place for two paras, if I may. It's a para 78. And 80, not one sentence. 78 said, it is by no means easy to impute a dishonest motive to the legislature of a state and hold that it acted malified and maliciously in passing the Bihar Land Reforms Act, or that it perpetrated a fraud on the constitution by enacting this law. it may be that some of the provisions of the Act may operate harshly on certain persons or a few of the zamindars and may be bad if they are in excess of the legislative power of the legislature. But from that circumstances does not follow that the whole enactment is a fraud in the constitution. From the premises that the estates of half a dozen zamindars may be expropriated without payment, one cannot jump to the conclusion that the whole of the enactment is a fraud or that all provisions as to payment of compensation are illusory. 79. Section 23F, however, in my opinion, is a colorable piece of legislation. It has been enacted under power conferred by legislative entry 42 of list 3. It is well directed, settled that Parliament with limited powers cannot do indirectly what it cannot do directly. In section para 18, the provision herein impeached has not been arrived at by laying down any principle of paying compensation, but in truth is designed to deprive a number of people of their property without payment of compensation. The state legislatures is authorized to pass an act in the interest of persons deprived of property under entry 42. They could not be permitted under that power to pass a law that operates to the detriment of those persons and the object of which provision is to deprive them of the compensation to a certain extent. Then, my lord, the issue was really this, that you cannot use an entry to nullify the purpose of that entry. Our submission today is, and there are other passages in the Honorable other Judges' Lord views at paras, specific Lord paras. (159) and 176, and all of them in essence say that we can't, under guise of granting compensation, the computation of compensation is what is permitted by the entry. Under that guise, you can't do away with compensation completely. So we can't have a situation where we nullify the provisions of the legislative purpose behind the PC Act, and therefore our solution is that these three legislations are a colorable piece of legislation. In this context, Lord, kindly just have a look at one more decision, which I would like to place, which is serial number 32 at volume 5, page 1969, Constitution Bench Judgment.
What is that?
Lord, this is the Ramanlal Keshalal Soni's case, and this is in the context of that Gujarat Panchayats Act. Lord. Here, there are two parts to it.
Call it implosive construction?
Yes, Lord, I would say implosive, not construction, implosive destruction in the construction. See page 1969.
Point is that whatever the provision of the law is there, you are amending it to defeat that very purpose.
Yes, Lord, that is not one of the.
That is your argument.
That is one of the arguments. The second will be to overcome Nagaraj, and I'll just place that part after this.
Overcome Nagaraj doesn't have, doesn't the legislature have a
Lord, it does, if it does away with the basis of the judgment.
jurisdiction by a legislative amendment to overcome the effect of any judgment?
It can, but the contours of that has also been described, Lord. The lordships have made it clear.
Extreme example is that Madan Mohan Patel.
Yes. Yes, ma'am. Yes, ma'am. Now, Lord, if I may just place this one, Lord, for a moment. Please just come to 1991. I'm not just seeing. That's all. Kindly just have a look at 1991,
Para?
para 33 note. We then come to the writ petitions. As mentioned by us earlier, the Gujarat Panchayats Act was amended during the pendency of the appeal in an effort to nullify the effect of the judgment of the Gujarat High Court. First, the government promulgated an ordinance. Next, the legislature enacted the amending act. By section 2 of the amending act, original section 11(1), which declared that Gram Panchayats, Taluk Panchayats, etc., shall constitute Panchayat organization of the state, was omitted. Original 11(2), which provided for the control of state government over Panchayats directly or through the officers, was made. It is extremely difficult to understand the omission of old 11(1). The whole object of the Gujarat Panchayats Act is democratic decentralization of power and the consequent reorganization of administration of local government. The object is to decentralize and reorganize, so it was thought that Gram Panchayats, Nagar Panchayats, Taluk Panchayats, District Panchayats should constitute the Panchayat organization of the state of Gujarat. The object of the act is still the same, yet 11(1) has been omitted. Does it mean that there is a disbandment of organization? According to the statements and objects, the amendments were necessitated to get over the judgment of the Gujarat High Court that Panchayat service is a state service. But surely that can't be a reason to go against the object of the Principal Act and to abandon the constitution of a state Panchayat organization. No wonder it was described as an act of cutting the nose to spite the face. You mention here that the section 2 was deemed to have come into force on February 24 when the original act was in force. Then not para 51. 1997. Now in 1978, before the amending act was passed, thanks to the provisions of the Principal Act of 1961, the ex-municipal employees who have been allocated to the Gram Panchayat service as secretaries, officers and servants of the Gram and Nagar Panchayats had achieved the status of government servants. Their status as government servants could not be extinguished so long as the posts were not abolished and services were not terminated in accordance with the provisions of 311 of the Constitution. Nor was it permissible to sing them out for differential treatment. That would offend Article 14. An attempt was made to justify the purported differentiation on the basis of history and ancestry, as it were. It is stated that Talatis and Kotwals who became secretaries, officers and servants were government servants even to start with, while municipal employees became secretaries, officers and servants were not. Each carried the mark or brand of his origin, and a classification on the basis of source from where they came to service claim was not permissible. We are clear it is not. Once they joined the common stream of service to perform same duties, clearly not permissible to make any classification. Such a classification would be unreasonable and entirely irrelevant to the object sought to be achieved. It is to navigate around these two obstacles of 311 and 14 that amending act is sought to be made retrospective to bring about an artificial situation in the erstwhile municipal employees never became. Can a law be made to destroy today's accrued constitutional rights by artificially reverting to a situation which existed 17 years ago? No. Legislation is pure and simple self-deceptive if we may use such a expression with reference to legislature-made law. The legislature is undoubtedly competent to legislate with a retrospective right to take away or repair any vested right acquired under existing laws. But since the laws are made under a written constitution and have to conform to the do's and don'ts of the constitution, neither prospective nor respective laws can be made so as to contravene fundamental rights. The law must satisfy the requirements of constitution parties taking into account the accrued or acquired rights. The law cannot say 20 years ago parties had no rights, therefore requirements of constitution will be satisfied if it is dated back 20 years. Now, based on that, at the last part of that page, last 8 lines of that page, we are therefore firmly of the view that Gujarat Act is unconstitutional as a defense 311 and 14 is arbitrary and unreasonable. We have considered the question whether any provision of the Panchayat's Third Amendment Act may be salvaged. We are afraid provisions are so intertwined that it is impossible to consider any life-saving surgery. This is the point that we were seeking to make. I would also like your lordship just to have a look at the decision in same volume at page 1855. 5. Now, the issue, Lord, is to what extent can you nullify a judgment? Please come to para 149 and 1943. And please come to below placetum C, 149 and 1943.
Para 149.
149 and 1943. Please just see that, Lord, 149, about the, just below placetum C, the constitutional principle. The constitutional principle that the legislature can render judicial decision ineffective by enacting validated law when its legislative field fundamentally altering or changing its character retrospectively has no application where a judicial decision has been rendered by recording a finding of fact. Under the pretense of power, the legislature cannot neutralize the effect of the judgment given after ascertainment of fact by means of evidence materials placed by the parties to the dispute. A decision which disposes of the matter by giving finding upon the fact is not open to change by legislature. A final judgment once renders operates and remains in force until altered by the court in appropriate proceeding. Our submission is Nagaraj in paras 15 to 21, 34, 40 to 44, 73 and 74 has given findings of fact. The nature of the activity, the nature of the cruelty, the nature of the sport, and why it is unjustified and contrary to the purpose of the act. In any case, but the findings of fact on the animals which are sought to be raised are clear, which have not been trammeled. Then Lord para 150. The 2006 Amendment Act plainly seeks to nullify the judgment of this court which is constitutionally impermissible. Moreover, it is not disputed by Kerala that the 2006 Amendment Act is not a validation enactment. Since the impugned act is not a validating law, it is not required to inquire whether in making validation, legislature has removed the defect which the court has found in existing law. 2006 Act in its application and effect of the Mulla Pariyar Dam is a legislation other than the substantially legislative, as it is aimed at nullifying the prior and authoritative decision of this court. The nub of infringement consists in the Kerala legislature revising the final judgment of this court in utter disregard of the constitutional principle that the revision of such final judgment must remain exclusively within the discretion of this court. And that is the principle, Lord. There are numerous other judgments which can be cited, Lord, and this issue regarding finding of fact is again reiterated in page para 157 at page 109, 1945. Question whether or not the legislature has usurped the judicial power or enacted a law in breach of separation of powers principle would depend on the facts of each case after considering the real effect of a law on a judgment or judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and judgment are inconsistent and irreconcilable so that both cannot stand together. In what we have already discussed, it is abundantly clear that on the one hand, there is the finding of fact determined by this court on hearing the parties on the basis of evidence materials placed on record in the judgment of this court in the Mulla Pariyar Environmental Protection Forum. On the other hand, the 2006 Amendment Act has declared the dam being an endangered one, fixed the water level. If the judgment of this court in Mulla Pariyar and the 2006 amendment are placed side by side insofar as safety of the dam for raising water level is concerned, it is obvious that the judgment of this court and the law enacted by Kerala State Legislature cannot stand together and they are irreconcilable and inconsistent. The impugned law is a classic case of nullification of a judgment simpliciter. As in the judgment of this court, the question of safety of dam was determined on the basis of materials placed before it and not on the interpretation of any existing law, and there was no occasion for the legislature to amend the law by altering the basis on which the judgment was founded. When the impugned judgment is not a validation law, there is no question of legislature removing the defect, as the court has not found any vice in the existing law and declared such law to be bad. So that is the principle. Not Indira Sani reiterates the same principle. I'll give your lordship the paras. I don't want to reiterate.
Only the multiplying because this is the
But I'm not going
principle.
to multiply. I'm not on Shaira. Lord Shaira Banu is the case on manifest arbitrariness. I'll just give your lordship the paragraphs, which my lord may just note. If my lord permits, Lord, I could have gone through them, but I would not like to take too much time. Lord, that's 2017, 9 SCC, page 1. Number reason we are concerned with Shaira Banu and the paras will be 72 onwards. Lord. There are two sets of paras, Lord, in Shaira Banu. If I may just point out, Lord, there is a discussion on how manifest arbitrariness came to be an accepted concept, Lord, 72 onwards. And then, Lord, there are a number of paras criticizing the McDowell case and why it didn't consider binding precedents. So I won't necessarily want to trouble your lordship on that. But kindly just note some of the crucial paras. But begin, I'm sorry, with 67. 67 at page 961 of the report. To 71. To 71. Then please look at 77 to 87, and I'll place 87 at page 977 of the report. In fact, Lord, just see para 85 for a moment, page 1975, because they'll answer another of your lordship's questions. Para 85 at 975. May I place that, Lord, for a moment? A question had been put to me, Lord, should we sit over parliamentary wisdom? And the answer lies here. The third reason given is that courts cannot sit in judgment over parliamentary wisdom. Our law reports are replete with instance after instance where parliamentary wisdom is successfully settled not by the court because such laws did not pass muster on account of them being unreasonable, which is referred to in Om Kumar. We must never forget the admonition given by Khanna J. In State of Punjab versus Khanchand. He said, it would be wrong to assume that there is an element of judicial arrogance in the act of courts in striking down an enactment. The Constitution is assigned to courts the function of determining as to whether laws made by legislature are in conformity with the provisions of the Constitution. In adjudicating the constitutional validity of statute, courts discharge an obligation which has been imposed upon them by the Constitution. Courts would be shirking in their responsibility if they hesitate to declare the provisions of the statute to be unconstitutional, even though those provisions are found to be violative of articles of the Constitution. But I won't read the rest. Please come to 87 at page 977. The thread of reasonableness runs through the entire fundamental rights chapter. What is manifestly arbitrary is obviously unreasonable and being contrary to the rule of law would violate 14. Further, there is an apparent contradiction in the three-judge bench in McDowell when it said that a constitutional challenge can succeed on the ground that a law is disproportionate, excessive or unreasonable. Yet such challenge would fail on the very ground of the law being unreasonable, unnecessary or unwarranted. The arbitrary doctrine when applied to legislation obviously would not involve the latter challenge but would involve the law being disproportionate, excessive or otherwise being manifestly unreasonable. All the aforesaid grounds therefore do not seek to differentiate between state action in various forms all of which are interdicted, they fall foul of the fundamental rights guaranteed to persons and citizens in Chapter 3. Then, Lord, please come to 95 for a moment. 95 at page 981 refers to national resources allocation and says that McDowell is not an authority. That legislation can never be struck down as being arbitrary. Relies on Ajay Hasya. Please come straight away to para number. My learned friend wants me to place one more aspect, Lord, of 95, Lord, at 981 bottom, last line. A constitutional infirmity is found in Article 14 itself when legislation is manifestly arbitrary. That is when it is not fair, not reasonable, discriminatory, not transparent, capricious, biased with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to norms which are rational, informed with reason, and guided by public interest. 96 will quote with Subramanian Swami.
Subject, does it come within the ambit of these principles?
Sorry, Lord?
The dispute we are dealing
Yes,
with,
Lord.
do they come within the,
Indeed, my Lord, and I'll tell your Lordship why. But why is this legislation arbitrary or manifestly arbitrary is something which your Lordship is to consider.
so far as nullifying the effect of judgment, you've understood your
But
argument.
that's one. Lord, the second argument is, but where is the necessity? How do you distinguish between two categories of animals to say bulls in races are distinct than bulls in agriculture or as pack or load carrying animals, draft animals? Now, Lord, these distinctions. And then the distinction also lies that whereas for the purpose of agriculture, whereas for the purpose of science, whereas for the purpose of load carrying, you have said that these animals are allowed to do so by virtue of the physiology and their nature, and also the fact that that is an accepted part of the activity which they can do even under the Act. However, 311 applies there and they have to be protected, and that's the reason also for the subordinate legislation, the draught animals rules, the pack animals rules, making them walk on foot rules, as also the fact not performing animals rules where they're exempted. But here you take them out of you nullify the effect of the 2011 notification, you take them out of the whole, you take them out of the application of the Act completely. So you're really saying by this that they are going to be taken out of the protective cover of that legislation. Now, Lord, with respect, that is the arbitrariness, because there is no basis to do that, no rational basis. And the absence of necessity makes it totally vulnerable on the ground of arbitrariness.
Yes.
Now, Lord, the last aspect will really be, and there are other decisions which one can please kindly just make a note of, Lord, para 100 and 101 of that judgment. Just make a note of that para, I'm not going to read them.
Shaira Manu.
Yes, Lord, 100, 101, 102. Our case, Lord, has been that when you look at, and that is the reason, Lord, I read to your Lordship that Kameshwar Singh's principle, when we look at the substance of the Act, because we really like to understand what is the basis of the Act, the pith and substance, where does it fall? That's not just to look at it from the purpose of what does it seek or achieve to do. It seeks or achieves cruelty, though it seeks to come under the entry of prevention of cruelty, and that was the purpose, Lord. When I touched on legislative competence, it was not so much legislative competence, it was the colorable nature of legislation, which I should have clarified, and I've done that. Now, Lord, the only thing that will remain to be addressed, Lord, which if your Lordships give me 10 minutes after lunch, will be on the presidential assent. Just 10 minutes and I'll 2:15, I'll be done.
But can you indicate what would you argue on that?
Lord, I will begin by pointing out, Lord, what is the contours of presidential assent, because they are now trying to fit this into two slots. On the one hand, their slot is that it will come under list 2. List 2, it's apparent it doesn't come. Apart from the Nagaraj lot, it's apparent on the reading of list 2. And that's the pith and substance too. Then not there that it comes under 254(2) because once they say it has got the assent of the president, therefore the law will prevail. Our point to be made is 254(2). Our point is the act of giving assent or seeking assent has a certain amount, has a connotation to it. Assent is not a mere idle formality. It is subject to judicial review and the contours of judicial review on that.
Oh.
There are no pleadings, there are no pleadings in any writ petition with
Not the-
regard to 254.
And I'll-
Yeah, you have certain other lawyers also to take over the charge. They will take care.
As not if your lordship give me 10 minutes, fine, otherwise I'll just 10 minutes. 2:15, no?
We can sit for 5-7 minutes more, complete it.
It's your lordship.
So that,
I'll finish if your lordship give me now. I know,
So that, you can start.
I don't believe not that somebody start afresh. Fresh minds and fresh thoughts will probably give greater clarity than I can. Now, but the argument on this has been twofold.
You are questioning the decision-making process in giving assent.
Yes, Lord. And the fact.
Have you taken as a ground in any of the writ petitions?
Well, I just tell your lordship what is exactly pleaded. I'll place that in a moment. My learned friend will just pull out the grounds that's taken on this aspect. But till there, that's done, not two things. Your lordship has seen the language of 254(2). I don't need to read it. The question that your lordship will want to consider is, have any of the three states placed any material before this court to show A, how there is a conflict between the 1960 Act, if any, and the Amendment Acts? And was this brought to the notice of the President? B, if this is not done, if the aspect of removal cruelty has come through the rules and not the principal act, then clearly it could not have been placed before the President, because all they've done in the principal act, say our amending acts, are to say Jallikattu, Kambala, races. All of the issues regarding cruelty and its safeguards come in the rules. They are not in the act, either of the three legislations. Our submission is, C, this having not been done and no material placed before your lordships, there is no question of protection under Article 254(2). The only document we have come across is Annexure A11, Maharashtra, page 38, Maharashtra compilation, a document dated 26 July 2017, which refers to 2 copies of those. Nothing else is done.
Is there any decision, precedent,
Yes,
where the manner of giving
Yes.
assent
yes,
has been questioned?
not enough, enough and more. Not enough and more. Kindly have a look at 2002 8 SCC 182.
Anyway, you just give us the citation.
But I'll give your lordship the two decisions. There will be two decisions which your lordship would like to look at. Both constitutional benches. Please note 1985 3 SCC 661. Gram Panchayat of village Jamalpur versus Malvinder Singh. Para 18. Para 12, I'm sorry, para 12, my mistake. Para 12. And Lord, here, there is a specific line at page 669 of the report that judgment of the High Court shows that hearing was adjourned to enable the state government to place material before the court showing the purpose for which the act was forwarded to consent and the reasons were not given. And assent of
Should
president.
it not be pleaded by you?
But I'll just pull out, but there is a pleading.
You have a definite key.
But I'll just give your lordship the exact pleading note. I'll place that, I'll give it to your lordship. Just make a note of the other decision note and I'll close with that. 2002, 8 SCC, 182. Again, a constitutional bench by judges. Kindly just note paras 1, 3, 8, 1, 14, 1, 3, 8, 14, 16, 20, 27 and 28. And not para 28 specifically deals with the High Court calling for the file and seeing what purpose assent was sought. Para 28 is specific. And paras 65, 73, and not 65 and 73 and 74 are in the supplemental judgment. But I will, if your lordship permits me, just place this one sentence for your lordship from para 20. It is true that the present attempt as notified nowhere mentions that assent was obtained for repugnancy between state legislation and government law.
But from this, it cannot also be inferred that Cabinet has given assent. All earlier laws on the subject would not prevail, as discussed above. Before grant of assent, considerations of reason for having such law is necessary, and consideration would mean consideration of the proposal made by state for the law enacted despite it being repugnant to the earlier law made by Parliament on the same subject. If the proposal made by state is limited for repugnancy of state law and law laws, then it cannot be said that the assent was granted for repugnancy between the state law and other laws for which no assent was sought. So, Lord, that is the principle in paragraph 20. I'll conclude with that, and I'll find that clause in our lordship. I'm most grateful for your lordship's kind consideration. Grateful.
is the pleading that on residential assent in petition 23 ground F, there's a reference to the residential assent not protecting the act.
Petition 20,
The petition number 23, the lead matter,
that's right.
ground F,
Ground.
page 54.
Lead matter is 24, 23.
Reading as to,
Residential assent not saving the act from repulsion. There's a pleading.
Yes.
Yes, Manoj, I appear for the petitioner in writ petition civil 1011 of 2017. My challenge is confined to the Tamil Nadu Act
1 minute, 10.
1011 of 2017. The respondent is the state of Tamil Nadu. My challenge is only to the Tamil Nadu Act. Now, responding to what Justice Rastogi had mentioned a short while ago, I wanted to just indicate what my points and the thrust, to use your lordship's expression, what's the thrust of my submission going to be? I'll state that first. I'll also like to indicate what I am not going to canvass, so that the scope is narrowed to whatever extent. And thereafter, I'll indicate as to how I plan to proceed. Now, my thrust is 3 or 4 points. It falls truly under this expression which was used and on which your lordships have framed the question, colorable. So the exercise, the Tamil Nadu Act amending the Prevention of Cruelty Act is a colorable exercise, and I'll just list the points. The first point is it completely seeks to destroy or is contrary to the well-entrenched principle of separation of powers. This is my first point. Second, the issues regarding cruelty, brutality, as far as Jallikattu and racing, etc. is concerned, have attained finality, and a very important principle repeatedly laid down by this court is that the fact that there is a certain conclusiveness to a final order which is passed. The third limb of the submission is going to be that we have now an emerging doctrine called, it comes under 2 names in international law, it's been adopted by this court, it's called non-retrogression or the progressive realization of rights. Under our constitution, which has been held to be a living document which responds to the changing times, we have progressive realization of rights. Rights move forward, they don't go back and shrink. So that's going to be a third limb. The fourth limb of our submissions is going to be that there are findings of fact which I will take you to in the judgment in Nagaraj, but keep that aside. There are subsequent facts which we have placed on the record in the form of, on affidavit, in the form of site inspection reports as to what is happening with regard to Jallikattu. And what you will find is that there is no difference, and now I am making the point. The point is our science and understanding regarding sentient creatures. So I'm not talking about trees, I'm not talking about mosquitoes, I'm talking about sentient creatures. That has advanced since 2014, and if anything, it should reinforce, or that will be our effort to persuade you that it reinforces the directions which Nagaraj has already laid out and which Nagaraj already points to. Finally, this was an interesting question which was posed in the first day, and the question was, in theory, can the Prevention of Cruelty to Act itself be fully repealed, etc.? What happens then, 1960? Or number 2, supposing, and I must answer it, so I'll answer it right away and then I'll elaborate on it. Or